This is part 2 in the series on things that get employers in trouble or traps that they should look out for. And the second one is employers not having an employee handbook. So I've been in practice for 38 years now, and I'm board certified in labor and employment law by the Texas Board of Legal Specialization. And the big part of my practice is management side employment law. And I've seen just about every mistake an employer can make. And I've had clients come to me many times through the years and say, oh, I don't need an employee handbook because that's just setting out rules that the employees can come back on me for. And they say, you didn't do this. Well, yeah, there may be some truth to that, but there's also a lot of protection for the employer in having guidelines and setting expectations for employees so they know what they're expected to do and what the consequences are if they fail to do that. Of course, as lawyers, we always have a caveat, and in Texas, we're considered an at-will employment state, which means generally you can fire an employee for any reason or no reason at all and without notice. Of course, and that's subject to not violating any of the other employment laws, but you want to be careful in an employee handbook that you set out that nothing in the handbook creates a contract between you and the employee that would alter the at-will status. But then you still set out guidelines, for instance, like attendance rules or calling in for tardiness, who you need to report to, and things of that nature. And another big thing that an employee handbook is very helpful for is that there are a couple of areas of the law that courts have outlined defenses that employers can claim if they have the policies in their handbook. One of them has to deal with paying employees incorrectly, and this is one of the areas where there is a lot of liability on employers lately. If you have what's called a safe harbor provision in your employee handbook that says if we made a mistake, you as the employee should call it to our attention and we will correct it just as quickly as possible. If you've done that, you can help limit your liability substantially. Another area where it's a safe harbor kind of defense provision that employers should have in handbooks is if they have 15 or more employees and they're covered by Title VII or the discrimination laws or the Age Discrimination Employment or the Americans with Disabilities Act. If they have, it's 20 or more employees for the Age Discrimination Act and 15 again for the Americans with Disabilities Act. But if you include in your handbook a procedure for an employee to report what they feel like has been discrimination or harassment, if they fail to follow that procedure, then that provides a defense if they bring a lawsuit against you. And that can be extremely important, again, and something an employer would want to do. And it also tells employees what their rights are. And again, under the law, there's some things that have to be in an employee handbook. If you're an employer with 50 or more employees, you're going to be covered within a 75-mile radius. You're going to be covered by the Family Medical Leave Act. And that law requires that you either put in an employee handbook or you provide to your employees somehow all of the provisions of the Act so they know what their rights are under the Family Medical Leave Act and what forms they need to complete and what the requirements are. So there's several really important reasons for employers to have handbooks, and I highly recommend that you get one if you don't have one.